Welcome to the Florida Divorce Podcast, your source for the information you need to successfully get through your divorce and into the next exciting chapter of life. Now, here's your host, Attorney Scott Kalish.
Hey everyone, my name is Scott Kalish and I am a divorce and family law attorney here in South Florida. Happy New Year, first and foremost. I'm recording this in January of 2024, so I hope everyone has a great New Year. Hopefully this is the first of many podcasts this year, so looking to stay consistent, so definitely stay tuned for additional episodes. But let's jump into the topic of today and of this podcast. And today I want to talk about the scenario of what really happens when someone lies on their financial affidavit about their assets, debts, income, in order to induce, or what I really mean, cause you, or if you do this to your spouse, cause the other spouse to accept certain terms in the divorce or in your paternity case, or causes the judge to rule a certain way, right? So what I'm really talking about is, essentially lying on your financial affidavit. And what a financial affidavit is, I believe I covered the topic of financial affidavits in a previous episode. If I haven't, I will definitely record an episode about financial affidavits. But a financial affidavit is a document that really, I would say, 90% of the people that go through divorce have to fill out as part of the divorce process. If you find yourself in a case where you have two lawyers and there's some sort of negotiation back and forth between you two, that then you're most likely doing a financial affidavit. And again, what a financial affidavit really looks like is it's basically a multiple page document, and there are two versions. One version for people that make less than 50,000 and another version that's for people that make over 50,000. And there's various components of the financial affidavit. So it starts off with asking your income, then it goes into your expenses, it goes into your assets, and it goes into your debts. And at the end of the financial affidavit, you have to basically sign under oath that, hey, you're swearing to the items that you put in the financial affidavit and that you're telling the truth, and you have to sign it. And most people have to notarize it. There's a way to not to notarize it, but I'm not going to get into that. But essentially, you're signing, swearing that everything that you put and you listed in the financial affidavit is true. And then you give it to the other side. You give it to your spouse's lawyer or your spouse, and it's up to them to review that financial affidavit and make a decision as to what they're going to accept in the divorce or paternity case, right? Based on your disclosure of your assets, your income, etc. So obviously there's people out there that are dishonest or less than honest that might not be totally truthful about what they put in the financial affidavit. And under Florida law, specifically the family law rules of procedure, there's a specific rule that gives us a tool to combat someone committing fraud. And what's really interesting about this rule is that to address someone submitting a fraudulent financial affidavit, there's actually no time limit to when you have to file your motion to what's called vacate the final judgment, right? So for a variety of different reasons, you can go back and readdress certain things procedurally in your divorce case, right? So let's say you end your divorce case there for a few different reasons. You can go back and reopen the case. And one of the reasons that you can go back or that will allow you to go back and readdress the issues of your divorce or paternity case is if someone committed or someone submitted a fraudulent financial affidavit. Now, for most reasons, there's a time limit that you have to file your motion within 1 year of the divorce or paternity final judgment. But in the case of a fraudulent financial affidavit, if you're claiming that your spouse submitted a fraudulent financial affidavit, there is no time limit. So you can come back whenever you want, right? So you can come back 2 years, 3 years, 4 years, 5 years, possibly even 10 years after the divorce final judgment is issued. So this is like a really, really important aspect of divorce and family law, that people need to be aware of. And it really, gives you an incentive and your spouse an incentive and motivation to always tell the truth and be as honest as possible on these financial affidavits. Because if it's ever construed that you committed fraud, that you didn't list something accurately, right? And you were doing that with the intent to deceive or induce your spouse into accepting a certain settlement, then it can be subject to attack. Obviously, there's going to be a cost-benefit analysis that's done, I think, by your spouse or you, if you're the one that was deceived, into whether or not it's worth it to reopen the case, right? Like if you could have gotten $5,000 more and attorney's fees are going to be 10 to do, or 15 to do this motion and reopen the case, obviously, it's not worth it. But in some cases, it definitely will be worth it if we're talking about significant money, or we're talking about someone that's just very principled, that doesn't enjoy being the victim of fraud, right? So I can totally see that happening. Let me give you guys some examples of like fraud that I can think of in a divorce or a paternity case. The first one that jumps into my mind is not disclosing an asset on the financial affidavit so that it's not divided in your divorce, right? So clearly in divorce, it happens all the time. Spouses don't have knowledge of certain assets, right? There could be a separate retirement account that someone was contributing to during the marriage that they have no idea existed. If the one spouse that has the retirement account doesn't list that on their financial affidavit, and therefore it's never divided in a divorce case, that's fraud. If it's intentionally left off with the intent to deceive the other spouse, that's fraud. So not disclosing assets so that they can't be divided. Another one that pops into my mind, right? Pretty easy, pretty clear, is not disclosing income so that the person with more income pays less in child support or alimony, right? So again, maybe not disclosing another source of income that the person has. Maybe there's a side hustle that one spouse does on the side, or gets paid for, maybe they're like an independent contractor with multiple clients and they're not disclosing, a significant source of income that is deposited into an account that is unknown to the other spouse, right? So some people have their own business or are independent contractors, and it's hard for the other spouse to really know exactly how many clients, exactly what income they're receiving. So I can totally see a scenario where one spouse does not disclose all of their income on the financial affidavit. This is another one, maybe overstating debts, right? Maybe lying about debts so that it appears in the overall property settlement that the one spouse is going to be taking way more debt than the other spouse. So therefore, they're going to get, more of the assets, or so that there's going to be less of an asset split, rather. So that at the end of the day, if they're overinflating debts, they're actually going to walk away with more assets. That one's a little bit more technical, but if you just think about it, I think it'll make sense to you. With the asset and debt division, if one spouse is taking a whole lot of debts, then, it's going to make sense for them to take more assets to even that out, right? We always, when we do equitable distribution, we look at, what marital debts, what marital assets is each spouse going to walk away with. So I can totally see a scenario where one spouse overstates their debts so that they walk away with more money. So if they overstate the debts and with the intent to deceive or defraud the other spouse, that would be fraud. And that would fall under this rule 12.540 that would allow the spouse that was the victim of fraud to come back and challenge the final judgment at the end of the case. So therefore, it's really important for people to be honest and straightforward when they're going through divorce, and to disclose all of your assets, to honestly disclose your debts, and to be truthful about your income, because you don't want to be the one getting served with a motion 5 years later to reopen your divorce case. I actually defended one of these cases about 2 years ago, where it was my client that was alleged to have committed fraud on his spouse. And in that case, I don't think my client fraudulently did anything. I think in that case, what ended up happening was they were both representing themselves during the divorce case, and they were in a really good spot, very, very amicable. And my client had a decent amount of wealth, and he didn't pay his spouse. It was a very short-term marriage. Didn't pay his spouse much of anything when they went through the divorce. And the wife was okay with that. Then, a few years later, she had remarried and actually remarried a lawyer from another country. And we think that he had a very big influence on her and encouraged her to go back and attempt to set aside the divorce agreement and the divorce judgment based on fraud, right? Basically saying that my client failed to disclose assets on his financial affidavit, et cetera, et cetera. We had a big hearing, 2-3 hour hearing, and ultimately my client won. The judge found that the former wife had knowledge of all of the assets, had knowledge of all of the income, and my client didn't commit fraud. But I tell you that story because my client was like panicked. He went through a divorce, a few years earlier, and there he was defending essentially another divorce case. When you're faced with a motion to set aside a divorce judgment and the other side is asking to reopen the case, you're essentially doing another mini divorce possibly, or you're staring down the barrel of doing another divorce. So if that sounds unpleasant, right, which I think it is for most people, for almost everybody, then you definitely want to be honest and straightforward. When you do the financial affidavit, make sure that you disclose all of your assets, disclose all of your debts accurately, and disclose your income, because you definitely don't want to be on the hook for going through a second divorce case. So that's essentially what could happen if you file a fraudulent financial affidavit. You will, or you can be the subject of a second divorce case. So definitely something that you're going to want to avoid. Never do it. Always be truthful. If you like this podcast, please give it a 5-star review on wherever you're listening. And if you have a question, feel free to ask me, shoot me over an email. My email is scott@kjlawfla.com. And if you're interested in taking the next step and learning about what working with our firm looks like, right, in your divorce or paternity case, give us a call. My number is 561-208-1859. Again, 561-208-1859. I appreciate you listening to the podcast, or this episode of the podcast, and look forward to the next one. Take care.
Thanks for listening to the Florida Divorce Podcast. To learn the 10 secrets behind every successful divorce, visit floridadivorcepodcast.com. If you'd like Scott's help in your divorce case, go to kjlawfla.com.